welcome to meeting number 31 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics.
Thursday, 26, Section 14.1 of the Lobbying Act and the motion adopted by the committee on Wednesday, September 17, 2025. The committee is commencing the statutory review of the Lobbying Act, and as such, I'd like to welcome with great anticipation, our witness for today from the Office of the Commissioner of Lobbying, Nancy Belanger. Oh, je m'excuse.
Monsieur le Président, juste une question de technicalité.
Chair, just a question. The sound in the room is very loud, and it's hard to hear our interpreters. Is it possible to lower the room volume, please?
Well, we're not off to a good start, Nance, but we're here. Right? Je vais faire un test. Je vais compter.
I will do a bit of a test. I'll count 1, 2, 3, 4, 5.
3. What comes after 3? 4, 5.
J'entends pas les interprètes.
Okay.
I still can't hear the interpreters. Yep. The interpreter would like to note that we've been speaking.
Is working right now. Is the interpretation working right now? Okay, c'est correct. Est-ce que le son est parfait? Okay.
Does it sound better now? Great. We'll start again. We have Nancy Belanger, Commissioner of Lobbying.
I invite you to take a little more time because you're here for 2 hours if you need it to address the committee. Go ahead, please. Okay.
Good afternoon, Mr. Chair and committee members. Thank you for inviting me today. I don't think I need to tell you all how excited I am that you are studying the Lobbying Act. I look forward to discussing my recommendations, which are informed by my office's experience in administering the Act and by that of my colleagues across the country overseeing their respective legislation. My mandate is threefold: to maintain the registry of lobbyists, to expand awareness and understanding of the lobbying regime through education, and to conduct compliance work that supports respect of the Act and the Lobbyist Code of Conduct. Last week, I shared with you 21 recommendations for improving and modernizing the Lobbying Act. These recommendations are aimed at enhancing transparency, expanding enforcement measures, and increasing efficiency. J'espère sincèrement que votre étude mène.
It is my sincere hope that this study will lead to improvements to the Lobbying Act. Amendments that enhance transparency will foster increased accountability, integrity, and trust in our federal institutions. In my view, these improvements would also serve to ensure Canada remains a global leader in the regulation of lobbying. I remain available to work with this committee, Parliament, and the Treasury Board Secretariat to move forward with any proposed amendments to the Lobbying Act and the associated regulations. Once you have heard from all the witnesses, I may present a further submission that reflects my views on the testimony and submissions that have been presented to you. I would also welcome the opportunity to return to answer any questions or clarifications you may need to complete your study. Mr. Chair and committee members, thank you, and I welcome your questions.
Ms. Belanger, and further to your comment about providing response, I expect that perhaps it may be the will of the committee to have you come back at the end of the study in order to review what the committee has heard during the course of the study. I would expect that to be a situation
disposal.
that could occur. Mr. Bear, we're going to start with you for 6 minutes. Go ahead, please.
Commissioner, the threshold to require registration is what?
Currently, under the Act, it's called a significant part of duties, which means it's a threshold for the employer once collectively all of the employees' work amount to a significant part of duties. That's been interpreted by the previous commissioners as being 20% of the collective work in a month, which was 32 hours. I have last July, I announced that I was reducing that threshold, and since January 19th, it is now 8 hours. Should be 0, but it's now 8 hours.
So that is 8 hours collectively for the organization.
Yes.
So you said it should be 0.
Yes.
If it were 0, if the threshold were removed entirely and lobbying had to, and anyone who was doing lobbying had to be registered to do so, how many additional lobbyists do you estimate would have to then register with your office?
I'm not sure what that amount would be. I can tell you that in the last 2 months, since January 19th, we've had 70 new organizations, corporations register.
As a result of the change
As
to the
a result
threshold.
of the change. I'm assuming it's as the result of the change. They were never registered before, so I have to assume that that's the case. So how many organizations and corporations lobbied less than 32 hours in a month? Probably a lot. Because I look at lobby days, for example. Lobby days, it's impressive how a number of organizations lobby on a full day of lobby day and they're not registered.
Right.
That's an example. So there'll likely be a lot more that need to register.
And would your office be able to manage that what you believe to be likely a lot more? Would you be able to manage with in the existing envelope of funding that you have and with your current staff complement? Would you be able to accommodate that?
So far, so good, because what happens is that the registrations are done by the organizations, and all we do is review it to ensure that it's appropriate and well done, and then we just click buttons. So are we busy? Yes. Can we handle it so far? Yes.
So your staff includes investigators, but I'm sure that you also have folks who do media monitoring as well.
Of course.
And so in your media monitoring, your staff observe that an organization successfully had meetings with, because MPs posted, let's say 200 MPs posted that they met with an organization and they are not registered to lobby. What do you do?
Currently, what I do is write letters to these organizations to explain the regime and to ensure that they understand. I ask them to respond that they understand the regime, and then they usually tell me that they stay under the 32 hours. That was the case then. 8 hours is going to be a little bit more difficult now. I will likely, I have not received any allegations of anyone under 8 hours so far. I might turn it right into a preliminary assessment to evaluate. But I do want to give people time to get used to this 32 hours. So I would likely write to them again. But that hasn't happened in the last 2 months.
Get used to the 8 hours, sorry.
Get used to the 8 hours, yes.
Which came into force?
January 19th. And of course, organizations have 2 months to register. So technically, they still until March 19th to register. So we haven't seen the full impact yet.
And an organization which you believe is doing substantial, were you to find an organization that you believe is exceeding the threshold, does not reply positively to your letter, then what's the remediation? What are the consequences?
So currently I would review, I do a preliminary assessment, and if I have reason to believe that they're not willing to comply or they're not complying, I would turn this into an investigation, because the threshold for investigation is if I have reason to believe that it's necessary to ensure compliance. And then if I have reason to believe an offense has occurred, I send to the RCMP.
How many cases are currently with the RCMP that you have referred to them?
4.
How many are you able to tell me did you advise us of during your last appearance before this committee?
The last time, when was the last time I appeared? I'm just thinking I have forwarded 3 in this fiscal year. So I've in my whole 9 years, I've referred 19. So I'm not sure what I would have said, probably 17, maybe 18.
And so they cleared a bunch of cases?
They cleared a bunch of, yes, there's been 2 charges laid.
Okay, and when were those charges laid?
One in 2024, and the other one in 2022, I believe, 2023.
And of the 4 that are currently resting with the RCMP?
One of them is one of the charges that are laid. That case has not finished, so it's still with the RCMP.
Okay. And that's where that includes
that counts one of them. Then there's 3 that they're investigating.
And for how long have they been with the RCMP?
The 3 that it's in this last fiscal year.
Oh, so those 3 are all within fiscal year 25, 26.
Yes.
Okay, more questions
Yes.
to follow. Thank you, ma'am.
Yes.
Okay, thank you, Mr. Barrett. Before I go to Ms. Church, has been standard practice at the committee. Oh, sorry, Madame Lapointe. It's been standard practice at this committee that we reset the clock after the first hour, which we're going to do to 6 minutes, and so that everybody will have a second round of 6-minute questions at the top of the hour. Madame Lapointe pour 6 minutes. Commencez.
Merci beaucoup. Bienvenue. Bienvenue à nouveau, Madame.
Welcome. Welcome again to our committee, Ms. Bélanger. We are very pleased to have you with us today and to know that we'll be receiving your recommendations and any explanations that we might need regarding the recent recommendations that you shared. Last time you were here, you talked about the lobbying regime in BC. You mentioned it as being a near-perfect model. In BC, there's a requirement for the registration threshold at 0. Apologies. I'm warming up. I'm still warming up. So lobbying needs to be registered as soon as it happens, and there are some measures for small companies or small businesses with fewer than 6 employees. So, saying that the BC model works very well, are there any things that could be realistically adapted to the federal regime? Answer: the BC regime is very avant-garde, and I would definitely consider inviting them. And in my recommendations, I mentioned that it's 8 hours because it's a threshold. We mention the significant part of the duties, and so I need to interpret the legislation, and I gave that, and I decided it would be 8 hours. In BC, there's registration by default unless a business has fewer than 6 employees or does it for fewer than 50 hours, but this does not apply if the goal of the business is to have lobbying activities. So if we're talking about an exemption that would be worth it at the federal level, it could be, but every time there's a number of hours associated, I'm always a little concerned because it's hard to have objective criteria for a threshold. So yes, it could be the number of employees, but it could have to do with the operational budget of a business to show how small perhaps the business is. But I would be very careful with exceptions, but of course we could have some. Would you like me to talk about other areas that are interesting for BC? Actually, I would like to come back to that registration by default. What does that mean? Answer: as soon as there's communication. If you look at the first page of the document that I sent you, if there's communication, oral, written, or through the public regarding a specific topic, if there's regarding a bill, a policy, any kind of funding approval, as soon as there's communication where one is asking for any kind of change, that's a lobbying communication that should be registered. That would be that automatic threshold. And so the person who does this communication would be the one that would need to be registered with the commissioner. Currently, if it's an employee, it's the manager that would need to register on behalf of their employees. One of my recommendations would be to ask those employees to let their manager know that registration needs to be done. But it would be one registration per organization. And in that registration, they would include all of the names of employees who are taking part in lobbying activities. Yes, now let's move back to BC, but I just wanted to clarify that before moving on. Another thing that is interesting in BC is communication reports. So once we're registered, there's an additional obligation. Currently, with the federal legislation, it's when there is a meeting, an in-person meeting that has been organized with designated public office holders. There's a responsibility to create a report to state that there was a meeting in person that was organized. In BC, that obligation extends to written communication as well, and that's what I find interesting. I don't see why you would exclude written communication and make the difference between that and oral communication. And it does not need to be organized in advance either. That's another potential issue. It's the subject matter that is important, not whether or not the communication happened in a cafe or in an airport lobby. All communication should be registered, not only those that have been pre-organized. And so if I'm at the airport and I meet with someone who is interested by my file, then I should report that I had a conversation, an informal discussion, because it is an informal discussion. You could call it informal, but whether or not it's formal shouldn't have an impact on the content. If they gave you the information that they wanted to give you and you heard them, whether it be in your office or at the airport, the fact that you heard it means that you were subject to that kind of activity, and that's what matters, I think. It's transparency for Canadians at the end of the day. It's not for me. It's not for these organizations or these corporations. This information is important in order to increase trust in our public institutions. If there are too many secret conversations, it's a problem. Thank you, Ms. Lapointe. Mr. Thériault, you have 6 minutes. What could help so that we don't differentiate between a formal and an informal discussion? Perhaps we could ensure that we don't have this 8-hour threshold, that it needs to be 0 hours, because I could have an impromptu meeting with someone and they'll say, well, it didn't meet that 8-hour threshold. That is exactly what's happening now. That's why it shouldn't be 8 hours, but I have no choice but to follow what's in the legislation. But that's my first recommendation, removing that threshold. That matter of significant part of the duties is found 3 times in the legislation, but it should be by default. It would remove that complexity whether or not somebody needs to be registered. We have communication, we need to be registered. It takes 5 minutes, and filling out the entire form takes fewer than 20 minutes. So it's some effort, minimal effort, in order to communicate with you. I don't know if you followed the work of this committee on the Conflict of Interest Act. Yes. I asked a question of the Prime Minister's Chief of Staff regarding the ethics screen, and he told us that they do not suggest to a Prime Minister. They tell the Prime Minister that he is not allowed to have meetings with any of the companies that are found on his ethics screen. And I asked whether or not they also tell Mr. Carney that he cannot receive any calls. And I will read the response that I received from Mr. Blanchard. He said, Mr. Carney knows his obligations. I would expect an answer saying, yes, we have told him that he cannot. Mr. Sebia and Mr. Blanchard said that they don't suggest to the Prime Minister, that they tell the Prime Minister what to do. The current legislation as written, and it was edited or amended in 2006, and there were 11 recommendations in 2011 that were never applied, and so now we're in an era of media, social media, and there are different means of communicating with people. After the pandemic, there was an increase of Zoom meetings, and so these technological advances, and given the way the legislation is written, is the legislation able to really frame all of this communication? If so, how? And if not, does it need to be further amended? To answer your question, I think that's one aspect of the Lobbying Act that's quite positive. We're talking about any form of communication. That's very different from some provinces where they talk about communications to influence. At the federal level, we don't talk about that influence. It's a communication regarding any kind of request, an amendment to the legislation. And so with that communication aspect, I find that it's easier to interpret. Communication via social media, that's communication. Communication by phone, it's communication. The way it's written is that whether it be through the public, written, oral, if somebody makes an ad in the newspaper to ask Canadians to speak to you, that is part of those communications and is included in the Lobbying Act. And so I think it applies quite generally, and so that's good. And we could say that it includes social media. But then how would we control that? How do we control that, the accessibility that is very different now? How can your office ensure that everything is done correctly? I have 35 employees and there are 15,000 lobbyists, and I'm expecting the number to increase. And can you say to the Prime Minister, you will give me your phone conversations? And yes, and I do that. I have asked public office holders to give me these communications, and I have no difficulty accessing this information. Would you be able to share those documents? It's in the context of certain investigations, so I would not be able to share that information, but I have asked for all communication, and I do verify this. Have you had to do it with the Prime Minister, given the particular situation that he finds himself in? Unfortunately, I won't be able to answer because I do not want to have any impact on any kind of processes that might be ongoing. So, when you are carrying out an investigation, that whole process is private. Yes, and when does it become public? It rarely becomes public, given the way that the legislation is written. I send everything to the RCMP. I do not have the power to say that somebody infringed upon the Lobbying Act. If I believe that there was an offense, I need to send that information to the RCMP. But you would like to have that power? Yes, absolutely. How much time do I have left, Chair? Thank you, Mr. Thériault.
Let's go ahead, please.
Thank you, Mr. Chair. Thank you, Commissioner. I want to look at some potential loopholes under the Lobbying Act with a view to closing them. In September 2024, Mark Carney was appointed by then Prime Minister Justin Trudeau as the chair of the Leaders' Task Force on Economic Growth. In this capacity, Carney had direct access to the Prime Minister. Indeed, Justin Trudeau touted Carney as his economic advisor. Normally, the economic advisor to the Prime Minister would be housed within the Prime Minister's office, but in this case, Carney technically was not. He was instead held out as an advisor to the leader of the Liberal Party, who just happened to be the Prime Minister. Had Carney been housed in the Prime Minister's office, he would have been a designated public office holder under the Lobbying Act, correct?
Had he been appointed under Section 128, yes, of the Public Service Employment Act, yes, he would have been a designated public office holder.
But because he was officially an advisor to the leader of the Liberal Party, he was not a designated public office holder under the Lobbying Act, correct?
Correct.
And consequently, any individual, corporation, or entity who would be subject to the Lobbying Act and therefore would have to report any meeting with a designated public office holder on matters of government policy would not have to report any meetings they had with Mark Carney discussing matters of government policy, correct?
Correct.
So in simple terms, we have no idea about who lobbied Mark Carney and what they lobbied him on while he was Justin Trudeau's economic advisor. Is that fair?
Unless there was some other transparent mechanism under the Lobbying Act, no.
Okay. So when you appeared before this committee on November 5th, 2024, you said with respect to the objectives of the Lobbying Act that, quote, it is important for transparency to make sure that Canadians know who's meeting whom and about what, and what leads to the decisions that decision makers are making, end of quote. Do you stand by those words?
Absolutely.
So while Mark Carney served as Justin Trudeau's economic advisor and had the ear of the Prime Minister on matters of government policy, we'll never know who he met with, what was discussed, and what influence those discussions had over decisions made by the Prime Minister and the government. So given that, would you agree that the arrangement Mark Carney had with Justin Trudeau was contrary to the spirit of the Lobbying Act?
Contrary to the spirit, I mean, there's different mechanism by which you can enhance transparency. So did this fit into the Lobbying Act? No. The question is as well, individuals who lobby the federal government also need to be paid. That's another requirement of the Lobbying Act currently. If someone is lobbying for free for a particular position, they're not covered by the Act, which is also something that we should be looking into, or if it's something that is of interest to this committee. In particular, for me, I'm not trying to reduce volunteer work and people that are coming to you as constituents because they have an issue. That's not what we're looking at. Yeah. But in particular, when people are former designated public office holders, they are prohibited from lobbying for 5 years, mainly because of the network that they've created. But if they go and volunteer for an organization, any communication that they have with their former colleagues is not covered by the Lobbying Act because they're doing it for free, possibly. So that is something that I think we need to put some thought to, for sure.
And Commissioner, I agree with you on that point, but I would also add that in the case of Mark Carney, serving as an advisor to the leader of the Liberal Party who just happened to be Prime Minister, it's not simply that it didn't fit in to the Lobbying Act. It appears to be a clear circumvention or attempt to circumvent the Lobbying Act in the same way that Mark Carney tried to circumvent the Conflict of Interest Act while he held that same role.
I'm not going to get into, what were the intents and whatever. I mean, that is the result, that
yes.
There is no monthly communication report with those individuals if this person was lobbied. I don't know to what extent that there was lobbying occurring of him.
Given that it is the result, whether you want to concede it was a circumvention, but you concede it's certainly the result, do you have any recommendations so that this sort of thing doesn't happen in the future?
We're going to have to come back to that, Mr. Cooper, if you don't mind. Ms. Church, 5 minutes.
Thank you, Mr. Chair, and welcome, Commissioner. I wanted to pick up on a couple of your recommendations, a couple of your later recommendations around the regulation-making power, maybe for starters. And could you just talk a little bit about, describe why those powers are necessary, what circumstances you think that they would be most useful in? What would they encompass?
They're definitely out of the box, that recommendation. But one of the reasons I made the recommendation is that the current regulations were in place in 2008 and they haven't been touched. And over the years, and I'll give you a very specific example, the subject matter, so the list of the types of things that people talk about, environment, health, these are topics that are provided by regulation. They were created in 2008. Some of the language in some of those are no longer appropriate, and they've never been updated. in our office, we're the ones who know how to update the regulations or how to update the registry to make it more in line with the current times. For example, climate is not in that list, but there's a category called other, and people were writing all sorts of things. So I took the liberty of adding climate, economic development, budget to that list of other, which really I'm not sure that I have the authority to do, but I added it as a list of items for people to add because they've never been updated. So that's one example. I still think that there should be this is not me asking for free power. I think there needs to be a process in place. But as an independent agent of Parliament, it's somewhat uncomfortable to have to go through the Department of the Day to make changes to regulations that would help to modernize the registry, for example. And I should have to come through this committee or through Parliament to be able to do that, and I should be able to do them without having to go through the department.
So just to clarify on that,
Yeah.
so I mean, because you do mention having an oversight process in place, do you see this committee or Parliament as that appropriate
It could be.
oversight?
It could be, but this would probably be very novel, but yes, it could be.
Are there examples of this in other regimes where these powers exist?
Not in the provincial. I know that Quebec is going to be asking for it. The other regimes at the federal level are tribunals, like the CRTC, for example, has powers to make regulations. It still goes through the Governor and Council. I think there's the Canadian Transportation Agency has a power to make regs that go through Governor and Council. So there aren't many models, and I know this is really pushing it, but it's to try to find a way to keep the registry and the issues and the items more modern without having to go through a big legislative review and do them through regulations, which is why some of the recommendations touch both.
And so is the primary issue there on the disclosures the nature of the theme of the communication or of the public policy area that's being communicated on?
That's one example, because there's a list. And the list, I mean, there was nothing about COVID, for example. None of us would have known in 2008 that there would have been communications about COVID and vaccines, for example. So there's health is the topic that people would write. So if there's a way to constantly to adapt and be flexible and be on top of creating a list that's more modern, which is more flexible, would be a really good thing.
The other recommendation I wanted to ask you about
Yes.
was with respect to enforcement of orders by the federal court.
Yes.
And if you could just help us understand
Yes.
a little bit more about the circumstances where you would think that would be necessary.
So currently, the Lobbying Act provides that I have the same powers of any superior court to issue production orders and subpoenas. Should somebody not abide by the production order or subpoena, you have to have contempt proceedings. Those contempt proceedings currently would likely have to go to the province of where the organization is instead of the federal court, because the federal court is a statutory court that takes its powers through statute. And right now it can review my decisions, but it can't do contempt proceedings necessarily of my orders. And so the Human Rights Commission, I gave examples of that we have precedents for, which all that would happen is that I would table my production order or my subpoena in federal court, and it would become an order of the court, and so any contempt proceedings would be in front of the federal court.
Okay, thank you, Ms. Church. Monsieur Thériault pour 5 minutes.
Vous avez parlé tout à l'heure.
Earlier, you talked about work that is paid or unpaid. Have you noticed many cases where such a situation would arise? There are many associations, organizations, groups that say that they aren't paid, so they don't need to be registered. So yes, it does happen regularly. Sometimes I try to tell them to be careful because they are associations that are said to be volunteers, but they would not be a part of that association if not for their employer. And I say to them that if they're doing it for their employer and not only for the association, they need to be registered. But again, my goal here is not to stop groups of volunteers from communicating with you. We need to find a middle ground for these organizations that are truly volunteer organizations compared to others that say that they're all volunteers when they might not necessarily be. In your recommendation number 21, the last one, I was actually quite surprised in reading it. It piqued my interest. People could say to you that they would take you to court Is this something that occurred? Is that why you have this recommendation? No, it has not happened, and I think that we're lucky. But I think that there would be a measure in common law that would protect us. So I do believe that we would be protected. But again, I think that it's something that was perhaps forgotten because parliamentarians all have that immunity. So I think it's something that needs to be fixed. And so that would also protect you and also tie into other powers that you are seeking, for example, the order-making powers, the disclosure powers, and not having to necessarily communicate offenses to the RCMP and to do it yourself. I believe in this natural justice process. If we are to have sanction powers to impose sanctions, well, I want to avoid any criminal or civil cases. You recommended disclosing cases where one goes through the public. We're not seeing this in any of the provinces. Could you give us an example where a disclosure would be necessary? Currently, about 60% of organizations are registered and 30% of corporations that state that going through the public will be a communication method. Once they check that box, we don't hear talk about it anymore. And then all of a sudden there's stuff in the news. I often hear from MPs and senators that they are being bombarded by letters regarding bills, and they have no idea who is behind all of these communications. And so the goal with that recommendation is to go beyond indicating that it is a method of communication. They will need to state that they are responsible for a campaign, that they are reaching out to MPs, senators, and they will have to indicate what the topic is as well. And so you'll be able to identify who is behind these campaigns. And how can that be operationalized when we don't know who is sending all of that? Well, we're hoping that it will be in the registry. You'll know when the campaign started and what the topic is, and you'll be able to see who the lobbyists are. Thank you. At recommendation 18 in your brief, you also state, Mr. Thériault, can we come back to this because your time is up? Yes, no problem. Mr. Hardy, you have 5 minutes. Thank you for being here with us today. Lobbying is the intention to communicate with public office holders in order to have an influence on their decisions. The legislation hasn't been reviewed since 2012, and things have changed significantly. And you talked about changes that has led to many new organizations being registered, and so things have changed greatly in the last 14 years. You talked about actions that are paid, those that aren't paid, and perhaps things that could be changed to make it clearer. If a consortium has 500 businesses, and every week one of those business leaders meets with for 2 hours, and they don't go over that 8 hours, so an hour and a half per week, that would never be verified. It flies under the radar, even though these are known businesses, and we might see decisions made that would be aligned with the goals of those businesses. Exactly. There's a threshold right now, and if the threshold isn't met, we're not made aware of anything. And you're saying that it doesn't have to be a lobbying business. It's any business could reach out to a minister, and if they don't meet that threshold of 8 hours, that means that ministers could be meeting for these businesses, and if they don't meet that 8-hour threshold, then it's fine. Indeed, there's no transparency. If a higher up in a business is mandated by a minister or a prime minister, and we're told this person should be able to give advice, but at the same time, they are at the head of a big business, and a lot of decisions are going to have an impact on that person. Do we consider that that person is carrying out lobbying activities? If the person is hired under a service contract to give advice, it's a service contract, and there are many of those at the federal government. That is not lobbying. However, I have given advice to many groups recently, these advisory boards and teams, and I've said that even though they are part of these groups at the request of a minister, if the activities and the communications could be seen as benefiting their company, and they're paid by that company to be there, and if it wasn't for that company or their expertise, they wouldn't be there, then it should be considered communication. I say that to them, and that's advice that I give them. It's advice. But as we've seen in the past, a person that is well known in finance could give advice to the federal government, even if it is not officially considered lobbying. If you had to give an example of something that is a conflict, but that is not included in the legislation, so something that's problematic, and you're thinking, well, that shouldn't have happened. Can you give an example? I know that comes back to the improvements that you mentioned, but if you have examples that you see frequently that you would like to share, just an example that flies under the radar. I think that a good example is people who are no longer public office holders. They cannot do any lobbying for 5 years. That said, if they work for a business, they can do lobbying up until a significant part of the duties. So, historically, if you leave and you go to work for a business and do lobbying, it used to be up to 32 hours, now it's 8 hours, and there's an exception for businesses once you leave. So that is included, and that is an issue, and there's no reasonable justification. I don't see why there would be an exception if you're working for a business and that you can do lobbying. So if you're well placed in government, that's fine. Well, it's been in place since 2008, so that is definitely an issue that needs to be solved. Thank you. Thank you, Ms. Bélanger. Mr. Saini, you have 5 minutes.
Thank you for appearing before the Commission again. Your recommendation 21, where you want yourself and your staff have the immunity. I know Mr. Theriault has asked the same question. Can you give some explanation why is it necessary? Also, are we going to be seen that you are a lobbying commissioner, but you also want immunity because you cannot be prosecuted if something people didn't agree with you?
I think if people don't agree with you, there are processes through federal court and judicial review to review my decisions, and I have no problem with that whatsoever. This immunity is the usual immunity that exists for all agents of Parliament, not to be criminally prosecuted or civilly prosecuted for doing my job. And this exists in all agents. I think it was just simply forgotten and just not added in. It's just, I don't know, an unfortunate event. And luckily, I've never been prosecuted or civilly charged. I think there's a concept in common law that would protect us in any event, but I just think this is a thing that needs to be fixed because all other agents of Parliament have it. We just don't.
Okay. Your recommendation under 19, where you want to amend the Act to include mechanism for the federal court to enforce orders issued by the... Does that power also rest with the other bodies like ethic commissioners, or would you be the first one who will get that authority?
It does not exist with the other agents of Parliament, but in any event, my colleague Access to Information have order-making powers, and there's a process in place. My issue is if there's contempt proceedings. I can't decide the contempt proceedings of orders I've issued. I'd have to go to provincial court, and this is just a mechanism by which the production order would be tabled in the federal court. I've never had to do this, but this is an administrative way to say if somebody doesn't show up or doesn't send me the documents, then the contempt proceedings would be at federal court, which I think is the right place for a federal agent of Parliament. That's all that is. It's very administrative in nature, but it's to save us problem in the future if ever we were to get there.
Your recommendation that you want to amend the Act that individual occupying Director General position be qualified as designated public office holder. What would be your reasoning behind it? And I understand there are hundreds of these people who have that position. Would that not create a lot more extra work for nothing?
Well, I don't know if it's for nothing. I will never say that work that enhances transparency is work for nothing. Recommending that Director Generals be included as designated public office holders comes actually from this committee. It was the #1 recommendation back in 2012. And the reason it was, usually Director Generals are invited to meetings because they're the ones that are operationally hands-on in departments, and so if people meet with them to get some work done, they should have to be transparent about those communications. So that was the recommendation of this committee. The only issue, people were concerned that they would also be subject to the 5-year prohibition, and that is the consideration that needs to decide if whether or not they should be in that group, and probably not. They don't have the same level of network, possibly. So that is the consideration, and that was a recommendation from this committee, to extend transparency to those who actually are working on the policies and are the operations of different departments.
Do you have any idea how many Director General positions there?
Oh, there's lots. There's lots. But that's okay. It's not on them. It's when an organization meets with a Director General, that is now a designated public office holder, they would have to go and indicate that they met with them. Takes 3 minutes.
Thank you.
I'll tell you, one of the issues right now is that people have a hard time figuring out who's a designated public office holder in departments. People don't have that written on their forehead. So if we bring down the level 1, maybe it's going to be easier to identify who they are.
Thank you.
Okay, thank you, Mr. Saini. Mr. Cooper, I have you for 5. Please go ahead.
Thank you, Mr. Chair. Commissioner, recommendation 10 that you provided is to amend the Act so that all members of the staff of ministers of the Crown and ministers of state, as well as Leader of the Opposition in both the House and the Senate, qualify as designated public office holders. I agree with that recommendation. I would put it to you that it's consistent with what you said with respect to the objectives of the Act when you appeared before this committee on November 5th, 2024, that it would help make Canadians aware of who is meeting with whom about what, that leads to decisions made by decision makers. Is that fair?
That is fair. My problem and the reason why I made that recommendation is because the Act makes reference to an actual section of the Act. So in the Act, it says Section 128, anyone in a minister's office that's appointed under 128 is a designated public office holders. There's never been an issue. Everyone in a ministerial staff is appointed under Section 128. Then through regulation, so the government of the day in 2010 added Section 128 for those staff members in the office of the Leader of the Opposition of the House, but also of the Senate. But those who work in the government representative of the Senate are nowhere mentioned. So I think that's a mistake as well. The problem is right now, by referencing Section 28 in the regs, it's misleading because I understand that no one in the office of the Leader of the Opposition is appointed under 128. Nobody is. So there needs to be a decision of whether or not they should be added in the Act and remove reference to 128 or remove reference to them completely. But right now, people out there believe that individuals in that office are appointed under 128, and therefore they report.
Right. Thank you for that clarification. Now, going back to the question that I put to you earlier, which was regarding the role of Mark Carney as the economic advisor to the Prime Minister, normally such a person would be housed within the Prime Minister's office, and therefore normally they would be a designated public office holder under the Lobbying Act, but because Mr. Carney was technically housed in the Liberal Party, even though he was directly accessing the Prime Minister, directly advising the Prime Minister on matters of government policy, specifically on economic policy. And therefore, as you noted, the effect of it, or the result of that arrangement, was that Mr. Carney was not subject to the Lobbying Act. Given that, what recommendation, if any, would you suggest to prevent something like that from happening going forward? Because whether there was a deliberate intent to circumvent the Act or not, and I think there likely was, it certainly is less than ideal from the standpoint of transparency and from the standpoint of knowing who is talking to someone who has significant influence on decisions of the Prime Minister and the government in terms of policy.
Well, if the intent is to have everyone in a minister's office be designated as designated public office holders, so therefore any communications with them would require a monthly report, or they would be subject to the 5-year prohibition when they leave, I think my recommendation in relation to removing a reference to a section, so it's anyone working in a minister's office, under whatever mechanism, whether it be contract, advisory, otherwise, be DPOHs, that is something this committee can definitely consider.
1 minute, just over. Yeah, but again, would that have applied in that particular case?
Well, if the definition is anyone working in the minister's office, as a staffer, as an advisor, then they would automatically be captured. And let's not forget, I don't regulate designated public office holders while they're in office. It's only when they leave that they become subject to my regime. But having designated public office holders, the greater the population, the more transparency in relation to communications with them.
Monsieur Sarré, 5 minutes.
Merci beaucoup, Monsieur le Président. Merci beaucoup.
Thank you, Chair. Thank you, Commissioner, for being with us. It's always a pleasure to hear from you. You did a lot of work before sharing these recommendations, and of course we might have some questions so that we can better understand how you got to these recommendations. And for those who are listening to us today, I would like to perhaps clarify a few things. We are currently reviewing the Lobbying Act. There's no scandal, nothing because when I listen to those across the room, we might get that impression. But we need to reassure everyone that we are doing this because the legislation needs to be reviewed. I would just like to clarify, have you had any difficulties receiving information from a minister's office? I have been experiencing a lot of respect from the departments and public office holders and offices. When I ask for information, I am given it. There's only perhaps some difficulties when a new minister arrives and it takes a little bit more time to get information, but I've never had any issues getting information. That includes the Prime Minister's office? Yes. I wanted to look at potential shortcomings, and so are there any shortcomings regarding your powers, and could you say it in simple terms if possible? I have great investigative powers. However, not all offenses need to be treated in the same way. Everything currently is sent to the RCMP. It's not complicated. I would like to have the power to ask or to tell people to take training. I would like to be able to impose penalties. These are things that my colleagues in the provinces can do, whereas I have to send everything to the RCMP. And for delays, we accept it for transparency, but perhaps there should be a sanction so that they won't be late next time. Regarding your answer to Mr. Cooper, the Office of the Opposition, does that include people under Section 128, even though it states that a minister or a person who's official opposition leader in the House of Commons or opposition leader at the House of Commons could name an executive assistant and other people to their offices? Is that an issue that is related to lobbying, given their position currently? For a public office holder in official opposition leaders, that's not in legislation, that's in a regulation from 2010. What I've been told and what has been confirmed is that no one in that office has been named under Section 128. And so, Canadians believe, or people rather, believe that they have to make communications report because they're named under Section 128, when in fact that is not the case. Are you the one who concluded that they're not appointed under Section 128? I asked for confirmation because I have to deal with a lot of people who say that they made a monthly report, and so I had to confirm that nobody from the official opposition was appointed under Section 128. And was there any kind of investigation to confirm that information? I can tell you that we verify these monthly reports. So on a monthly basis, I communicate with your offices, senators' offices, ministers' offices, and departmental offices, and we ask the question, did this communication occur? And it has been confirmed that these people are not designated public office holders because they are not appointed under Section 128. It's a question that was asked of me recently, and I wrote to the office in order to confirm whether or not somebody was appointed under Section 128. What about the staff for the official opposition leader? Same there. Thank you, Mr. Sarri. This ends our first hour. Ms. Bélanger, would you need a short break? No, we can move straight on. We're going to start with Mr. Hardy for 6 minutes. This is very interesting. Thank you for being with us today. I think it was overdue for us to review this legislation. Now, for businesses that carry out lobbying activities, there are over 9,000, I believe, over 9,000 that you mentioned. Do you know who funds these businesses? Can you ask them how they are funded? Because that could be problematic. 9,000 is the number of lobbyists. There aren't enough 9,000 businesses, rather. For these businesses, under the legislation, they must disclose the funding that they receive that is not government funding. But they don't currently have any obligation to declare the funding for lobbying activities, which is one of my recommendations, by the way, because it is something that you can find in provincial legislation. Currently, there is no obligation to disclose. Would I need this information for... Not necessarily. I don't think I've had to ask for that information. You stated earlier that transparency is extremely important and people are losing trust in our institutions, and some people might believe that public office holders are working for their own interests. And we're talking about Canadian businesses, but we could talk about foreign governments as well. That would be relevant to talk about. Currently, consultant lobbyists need to declare those who have any interest in the lobbying activities, but there isn't any obligation for employers, for corporations and associations. They don't have to disclose who is funding the lobbying activities. We could do it. In the provinces, it's $1,000. $1,000 is the threshold, but that is one of my recommendations. So there's nothing in Canada, but that could be a good idea. If you notice that there's an issue and you start an investigation, you mentioned earlier that the only thing that you can do is send this on to the RCMP. Many commissioners have said to us that they are supposed to be above the government and ensure that public office holders are doing their jobs correctly, whether it be for ethics, access to information, or lobbying. Often they tell us that they don't have enough funding or sufficient power. Do you believe that you have enough power in order to ensure that you can maintain the public's trust? I have enough power for these investigations, but it's regarding results where I feel like I have insufficient powers. I can't talk to you about it, for example. And I would love to say this was an offense. It was not the worst offense. I was able to impose a penalty. It will be in the public domain and we'll be able to talk about it. You can't speak about an organization. To ban any kind of lobbying. I can only do that if the organization or the person was found guilty. So throughout that time, you can see that there's an issue, that things are problematic. The RCMP takes the time to investigate, and if eventually a decision is rendered and it's out of your hands. Yes. If a meeting happens with a private business, as we mentioned earlier, but they're 20 to meet with a minister and they've got graphics and tables, books, 20 people who come once a week, 1.5 hours, 20 people. Is that counted as 1.5 hours? No, cumulative. And that is included in the current legislation. If it's 20 people for 1.5 hours, they need to be registered. Yes, understood. As we said earlier, if a meeting happens on a regular basis, that could be registered or not. Do you monitor all of the phone calls that can happen after that? Can you state, or do you have the power to ask for that, or do you absolutely need to start an investigation to have that telephone information? The way things are organized, we have to trust people. And so I have 35 members of my team, and so if historically these organizations have been registered and they fill out their monthly reports, I have no reason to believe that they're not following the legislation. But if I see that there are meetings, and you'd be surprised to know the number of emails and photos where people are doing lobbying and they're not registered, well, then I'm going to do some research, and I'll ask you what the meeting was about. Was there any further communication? And if the answer is yes, I calculate that to see if it meets the 32 hours, and I send that to the RCMP. Coming back to my example from earlier, a business that's meeting with someone, a minister, 1.5 hours per week, and so that's under that 8-hour threshold, but they speak outside of that meeting for 3 hours every day, that's not registered. Well, somebody would have to make an allegation, and then I would have to see whether or not that 8 hours was exceeded. But could you ask on a random basis without necessarily going through an investigation? Could you ask for telephone through telephone records? Ms. Lapointe, you have 6 minutes. Thank you. Thank you for responding to our questions. I would like to come back to what my colleague Abdelak was asking earlier regarding people who are part of the official opposition and that they are not registered. Is that surprising to you that none of them are registered? They are not registered. We're talking about lobbyists who need to register their communications, and they do it because they assume that the employees of that office are appointed under Section 128, but it has been confirmed to me that nobody has been appointed under Section 128, so these communication reports are not necessary. But we need to clarify. We need to decide whether we keep that Section 128, and if so, then it needs to be in the legislation for everyone. And I would remove a reference to sections in legislations because the legislation can change, the numbers can change, and we need to decide who needs to be considered a designated public office holder and include that list in the legislation. So that would clarify things. As soon as one attempts to have any kind of influence, they should be registered. Thank you. That is important. Earlier, we talked about the Lobbying Act and the BC Lobbying Act. Would you have anything else to add? You talked about in-person meetings and being transparent and removing the threshold. Was there anything else that you wanted to add? In BC, they also have an obligation that I mentioned earlier where people need to disclose if they're receiving funding in order to support their lobbying activities. This is something that you can find in Ontario, Alberta, and BC. But that's also interesting as well. All right, on your recommendation 15, you talked about 5-year restrictions. I would like to have some information on that. I think that in BC, they give 2 years for those public office holders, and for some institutions it's 1 year. I would like to know why you think 5 years is better than BC's 2. 5 years, that was the decision made by Parliament in 2008. I didn't make that decision on that 5 years. It's included in the legislation, and I apply the legislation as it is written. Currently, a designated public office holder who leaves is not able to do lobbying unless they are doing it on behalf of a business, but they cannot exceed that 8-hour threshold, and I believe that that needs to be changed. Whether or not to keep the 5 years, I know that's a long time. However, for some people, it perhaps should be more than 5 years. For some people, I believe that 5 years is reasonable. And the way that that section is written gives me a lot of flexibility to look at a case on a case-by-case basis to see if conditions could be imposed, if we could reduce that 5 years for people who have administrative tasks who are not there for very long. So there are criteria so that we can be flexible and to ensure that not everyone is subject to that 5-year restriction. Some have said that we could have categories depending on the amount of years worked. But for someone who's in a more junior position, but they've been working for different ministers for 15 years, well, they have a network that's just as good as someone who is a minister for 3 years. So we need to be careful there. That restriction is to stop former designated public office holders. We want to stop them from giving any kind of advantage to their new client or people that they've met with information that they acquired through their years of work. So it's difficult. We can't just include certain positions. So it's not so much the position as some of the criteria. Is this something that happens frequently, that former designated public office holders ask you to reduce that 5-year restriction? We, in the last year, received 23 requests. I think that there are 2 that we are still currently working on. I think that I think it was about 50-50. It's not former ministers or former MPs that ask me this. It's employees who worked in ministers' offices who make that request. They say, I worked for 6 months, I wasn't there very long, I only did administrative tasks. Could I be exempt from that 5-year restriction? I would like to come back on the volunteer associations. And we see that quite often, depending on the sector. You're an entrepreneur, you're part of an association, and you're doing a volunteer representation. Would it be the association that then should be registered? That's what we're saying. If the association has an employee, then it's the highest level of management that needs to register. But some will say that none of us are paid. We're doing lobbying on behalf of the association. None of us are being paid for it. I have an issue with that, especially if that lobbying, that volunteer lobbying that is done during business hours, is it true volunteering, or is it because they're representing their employer? Thank you. Mr. Thériault, you have 6 minutes. Earlier, you were talking about a list of designated public office holders. Do you have any ideas? Perhaps I was not clear. There's already a definition, and one of the aspects has to do with Section 128. Remove Section 128 and determine who works for a minister's office, for example, and there's also a regulation, and it includes a lengthy list of people who are designated public office holders who could be added to the legislation. There also seems to be criteria so that someone could be exempt regarding that 5-year restriction. Do we know those criteria? Yes. When somebody says that they didn't work for very long, that's in the legislation? Yes. The legislation says that the commissioner, in examining different factors, including whether or not somebody was there on an interim basis for a short time or doing administrative work. And so you can determine whether or not this person respects those definitions, wasn't there for a long time. Yes. And I look at other factors as well. I look at the entirety of the situation. I was just curious regarding how that works, because I do know that sometimes the legislation can be quite general in its application. last time we spoke in October, you talked about the Yukon and how it had integrated a notion on these dirigeants, so directing entities, and they talked about it as though it was a directing minds, rather. And there isn't that notion of payment. And so someone who's on a board and does work, volunteer work, and is doing lobbying, these people would not be registered. So for this, I do find this matter of directing minds interesting, especially if they are directing some of the work of a business and they are choosing to not be paid. And we can't control that, of course. We can't verify it either. I can verify if I carry out an investigation. If we want to summarize, you want discretionary powers in order to make files public, and that's for transparency. And you're saying that it's very difficult to have full transparency with the legislation. Yes, I believe that you have understood me. And when the RCMP closes a file, they send it back to me, they say that the case is closed. Honestly, I could report to Parliament explaining the work that I did. That said, if I do that, the natural justice processes would be triggered. I need to communicate with people that I communicated 2, 3, 4 years ago. Sometimes these organizations don't exist anymore. And the legislation tells me to investigate, and if the RCMP investigates and decides not to move forward, I'm not sure what I could do with my team. Could I have a report explaining all of that? Maybe. But I think I don't know that I would be allowed to do that. And when you talk about forcing people to do training, if someone is late, I have to accept. We could tell them to do training with my team. Some do it, some don't. I would like to have the power to say, this is your 3rd time being late, you're going to follow this training. Next time, it'll be a penalty. And perhaps next time, you'll be banned from doing some lobbying work. And the time after that, you'll be investigated by the RCMP. I want to have some options to ensure that the legislation is being followed. I don't want to have to investigate only the most significant issues. There are plenty of small things that happen that I can't do anything about. Do you believe that in certain cases that when people are late, is it because they don't understand and it's not necessarily negligent? I believe that oftentimes people don't fully understand. Some might think that they didn't know that they were doing lobbying and they were told by public servants that they needed to be registered. But when it's the same people who are late all the time, well, there are people who do lobbying who are not registered, and then you find out in the newspaper, and while it's in the newspaper, that's when they decide to register. So perhaps there should be a penalty there instead of sending it to the RCMP. Thank you, Mr. Thériault. Mr. Barrett.
So with respect to the post-employment lobbying activity ban for former members of Parliament, I'm going to use a real-life example so that I can understand it, because it's something that I've been asked about several times. So the former defense minister, Mr. Sajjan, has started a defense technology company. And their stated intention is to help answer the, be an answer to the problem that is the gap that we currently have in the defense tech sector in Canada, created by the fracture in the closeness of our relationship with the U.S. and companies there. And so the government has said that there's an awful lot of money and very specific pots of money that are available for small and medium-sized companies, specifically like this one. And Mr. Sajjan's company has identified itself as seeking some of those pots of money. Now, to my knowledge, Mr. Sajjan has not contacted any government officials. I'm not making any accusations or anything like that. What I want to understand, though, is in an example like this, so former public office holder, former member of parliament, former cabinet minister starts a company, and their company, well, they don't have any customers, so the first person they hire is someone to go to the government and say, hey, here's what we can do, and we've got this guy, and he's got really great experience. He's he's a Canadian Forces veteran. He's a former cabinet minister. He's a former member of parliament. Super, he's had great visibility on what D&D capability gaps were, and we think that we can fill those gaps for you. Now, in this example, as we're going to assume innocence is likely the case, that Mr. Sajjan has not directly communicated with anyone in government. Does that respect an example like that? And truly, I'm not trying to indict or cast aspersions about this example. I hope that there's life after politics for everybody. But what I want to know is, do we have a regime that's set up that actually, both in practice and in spirit, does ensure Canadians' confidence that there isn't a two-tier system when it comes to lobbying the government?
This is a very complex question you've just asked. So I'll start with the beginning. A former minister would then have to clear whatever work he's or she wants to do in the future with the Conflict of Interest and Ethics Office. So let's assume that's been done and that's cleared. Assume. Then any communication in relation to a contract. So this example you're giving me is a corporation. So it's a for-profit. Therefore, that individual would be able to lobby up to a significant part of their work. Therefore, up to 8 hours, historically up to 32 hours. So this person, according to the Lobbying Act, is entitled to lobby up to 8 hours. That's a problem. So that's the first thing that needs to be fixed.
Sorry, ma'am, for clarity, which the former
Yes,
in the hypothetical,
a former minister who
yes.
opens up their own business, which is for profit, would be allowed to lobby up to 8 hours, because that's what the law says right now. If they go work for a charitable organization, they can't lobby. But if they go work for a corporation, they can. That's the first thing. Any communication, however, in relation to obtaining a contract is not lobbying, which is one of my recommendations for a company. If you hire a consultant to get you the contract, it's considered lobbying if it's for a contract. But a communication in relation to a contract for employers, for organizations and corporations, is not covered under the Lobbying Act. So the communications you're telling me about, if it's to obtain a contract, would not be lobbying. If, however, it's to get contributions, if it's to get contributions, grants, then that's lobbying, and that would be covered by the and that person would not be entitled to do it. If they send their employee to do it for them, it's okay. If they send their employee to do it for them.
I have more questions,
I'm
but
sure
I have
you
no
do.
more time.
Yeah,
This is the worst part of my
I
job.
tried to fix that issue in one of my recommendations.
What, to give me more time to designate to members of the committee to ask their questions?
I'll take it.
Oh, that, okay. Ms.
It's
Church,
a
5 minutes,
complex
go ahead.
regime.
Thank you. And Commissioner, thank you for, I think, bringing up the careful interaction between the lobbying regime and the ethics regime, and the interplay, I think, of even aspects like cooling off periods, which may also be pertinent in various situations post-employment. My question, I have a few for you. First of all, grassroots lobbying versus public advocacy. What is grassroots lobbying? What does that encompass in your view?
According to the law, it is when an organization, corporation, consultant, lobbyist uses in what they call an appeal to Canadians to communicate with decision makers to change their mind, to influence them about an issue. So it's ads in the paper. Please call your member of parliament about C whatever and tell them what your opinion is on this.
But only a consultant lobbying organization?
No, orgs and corps as well.
Okay. Orgs.
Everybody. It's grassroots lobbying is considered a communication method for everyone that lobbies.
Okay. And how would they how would you register that or designate it, or is it a designation on the actual communication that is calling to action the public?
Currently, the only thing that they need to do is when they do their registration, they need to do a check mark that they will be using grassroots as a method of communication.
But they don't have to describe what it is or how or where?
There's nothing, which is why my recommendation is to try and add a bit of meat to that. In particular, when it begins. Maybe they intend, they haven't started it, but in 6 months, when they do the actual campaign, they should be going into the registry to say, okay, we're doing it now.
Okay. On another point,
Yes.
you recommend registering all oral or written communications regardless of whether they are arranged in advance. And I just wanted to ask you a little bit about, do you see any challenges with that? Do you envision any constraints on that as a parliamentarian? In some ways, that's one of the recommendations that stands out to me in terms of creating perceptions of lobbying and access where there actually might not be any. How do you see that playing out in practice?
To me, as I've said before, whether a communication is arranged in advance is somewhat irrelevant. It's the substance of the communication that matters. So if someone lobbies you and has an ask of you, whether it's at the airport, whether it's in your office, the substance of the communication matters, and that's what should be recorded and reported. If people come to you and say to you, this is going to absolutely invade the registry and completely be a burden, then you should all be worried. That means because it's happening, and it's happening a lot, and there's no transparency about it.
Actually, I worry about cases where it would appear that I was being lobbied as a parliamentarian by organizations I may not want to be or accept lobbying by. So that's the situation that I'm worried about.
Well, that's interesting because you can always reach out to my office and tell me that that lobbying activity did not occur, and I will be asking them to remove it, which is what I do now when I do my verifications. I pick 5% completely random of reports, of oral reports, and I check with you, and if you tell me that never happened, I was never there, I go back and I get them to remove it if that didn't happen.
But for example, if
Yeah.
they were to send an email to one of our offices that we
Yeah.
receive because we have inboxes, we are not in control of whether we've received that communication or not.
So currently, that would not be a requirement because it's only oral and
Right.
arranged. But in the future, those emails, if they actually communicated with your office, they would have to put in that whoever they sent it to. If they didn't send it to you and they sent it to your staff, then your staff would have to be, if they're a DPOH, I'm not expanding, they would have to say that they sent it to you. And that's what they're doing in BC now.
Right.
So you could ask them if it's a
Finally,
concern.
let me come back to the question about the staff of the Office of the Leader of the Opposition not currently existing as designated public office holders. In your mind, does that mean that there could be missing records filed because there actually is not a necessity right now to provide records of communications as the members of the OLO are not DPOHs?
I think currently most of those who lobby assume that they are. So there is a lot of monthly communication reports that are in the report. The problem is they technically don't need to be because they're not DPOHs.
But it would be an assumption and voluntary is what you're saying at the moment. As
yes,
opposed
right
to
now is people
required.
assume they are in, yes. And we need to clarify whether.
Thank you.
Thank you, Ms. Church. I think that's a good matter of practice for all members of Parliament, and sometimes it gets lost with newer members of Parliament to have your staff check the lobbyist registry on a monthly basis to see whether, in fact, there is a registered lobbying that's put to you when it's not actually. So that happens happens frequently.
And you can register to have emails sent to you directly when your name pops
Right,
up, so
right.
you can actually fix it all up with your staff to have that done.
Thank you. Monsieur Thériault pour 5 minutes.
Mr. Thériault, you have 5 minutes. The Information and Privacy Commissioner now has order-making powers. Would you consider that such order-making powers would help you? Yes. I already can ask for subpoenas and production orders, but yes, I wouldn't mind additional powers. That's a great idea. Recommendation 20. You recommend a new section regarding the content of disclosures required to be made in the registry. Why would that be necessary? I believe that the information has not been updated. Regulations exist for meetings that were organized, but things haven't changed since 2008. There are things that I would like to change that I don't have the power to change, and if I make recommendations, I need to do so through the government of the day instead of going through Parliament, for example. I'm not asking for authorization without consideration or consultation, but it would be interesting to share recommendations without waiting for a review of the legislation. In recommendation 17, we talked about this earlier. You talked about mandatory training, administrative penalties. What would be the amounts for these sanctions or these monetary penalties? In the provinces, it's 25,000. My colleague in BC often has to impose monetary penalties, and it rarely goes over $8,000. And in what circumstances? Often it's an offense. So if somebody was not registered when they should have been, so communication without being registered, it could be somebody who is doing lobbying when they are not allowed to do so, sharing false information, being late, that kind of thing. Would you ban a person from lobbying activities? And if so, what would be the circumstances? Also, how long should a temporary ban last? My colleagues have this authority, and it can go up to 2 years. I can ban someone from carrying out lobbying activities, but only when they were found guilty of a criminal offense. And that's happened in the past 4 times. But it would really be for cases where someone really did not want to follow the law and they were acting in a negligent manner. It would have to be a pretty intense case, probably. With your current powers, you can't do that. No, I have to send everything to the RCMP. I can't do anything. What I currently do For example, if somebody's late, that's an offense. But I don't send these files to the RCMP. I accept, for the sake of transparency, sometimes I ask to meet with them to see why they're always late. But that's it. There's not much more I can do. So it's the RCMP that has the expertise then. Well, you could invite them to testify and they'll be able to explain it to you. They're like me. They don't believe that all offenses are equal, and so there should be some flexibility. Do I still have time? Yes. Some people have said to us that the Conflict of Interest Act, the Lobbying Act, and for public office holders, that all those rules should be included in a single legislation. What do you think of that? I would be careful, because lobbying is not only done with MPs and ministers. Lobbying happens with senators and with departments. I am not a mirror of the conflicts of interest in the Ethics Commission. We could deal with senators and associate deputy ministers who currently do not fall under the purview of the Ethics Commissioner. Mr. Cooper.
Sorry, Mr. Barrett, go ahead.
Our momentum got interrupted, Commissioner. So a former minister would has to clear their new work or profession or their startup with the Ethics Commissioner. And they would only need to register to lobby if they personally are lobbying for 8 hours per month, and only if that's to request grants or contributions, because that's covered by the Act. However, a former minister or a former member can start a company, and they can pick up the phone and they could call one of their former cabinet colleagues and say, hey, we're doing this thing that's compatible with that thing that you're about to spend $1 billion on or billions of dollars on, and we think we're right for you. And that is not captured by the Lobbying Act. Do I understand that correctly?
So if the communication that they're having is about getting a contract, contracts are not covered under the Lobbying Act for organizations and corporations. That's a problem, and I have a recommendation about that.
Tell me what your recommendation is for it.
My recommendation is that any communication in relation to contracts should be included in the Lobbying Act, except, and that's what they've done in provinces, anything that is a communication that is within the parameters of a public process, like RFPs or standing offers. Those that are already transparent don't need to be covered by the Lobbying Act. But anything that's outside of that, so that phone call to say, hey, I think we align and I think we should be able to work together, would be outside possibly of a context that's in the public domain, and that should be covered.
But it's currently not covered.
It's not covered.
Okay. And so what's more, in this case, in the example that I gave, the public reporting in the Financial Post was that Mr. Sajan has also been retained by the province of British Columbia to advise them on how to get this money as well, on how to get identify business opportunities to tap into the government's defense spending, also as an advisor. Then that works. So there's really no current practical limit to the connections and influence in securing government contracts by former ministers and members.
Securing government contracts, getting contracts is not covered by the Lobbying Act right now. So any communication by former designated public officers.
And your recommendation is that it ought to be covered?
It ought to be covered,
okay.
Yes.
How much time do I have, Chair?
You have 2 minutes.
Okay, with that, I will in fact turn it over to Mr. Cooper because he had a question that was born out of that. Thank you for your response, ma'am.
Okay, go ahead, Mr. Cooper.
Thank you, Mr. Chair. Just further expanding on understanding the scope of the 5-year prohibition on lobbying for designated public office holders, you noted that if a designated public office holder is working for a corporation, they can lobby 8 hours per month. That's a problem. I agree. If they're employed by an organization, they can't. If they tried to go out and lobby themselves in a consultant capacity, they couldn't do that. But what if they set up their own firm, hired people to engage in those very activities, using their name, using their reputation, and using their personal contacts? Would that be captured by the prohibition?
If they're not the ones communicating right now, it's not covered. They need to be the one communicating. So if someone else communicates on their behalf, they're not the ones communicating.
Well, it seems to me that that's a pretty big loophole.
Well, people call this shadow lobbying. They send someone else to do the lobby for them. But at some point, where do we put the line? I don't know. It's not an easy one to regulate. And you know, the revolving door from going one side to the next, sometimes you want people's expertise and knowledge in certain areas. So we got to be careful about that as well. They can't be using their networks. They can't be the ones communicate. If someone else does it for them, what can I do, really?
Okay. Thank you. Mr. Saini, 5 minutes. Go ahead.
Thank you again. In your submission to the committee, you recommended that the member of the board of directors be deemed employees of the organization or corporation to whom board they sit. Why do you think this amendment is necessary to the Lobbying Act?
So currently, board members of organizations have to register if they lobby for their organization, but their organization is like deemed their client, which is awkward. So if there's 4 board members on an organization, all 4 of them have to go and register 4 different registrations for each of them, instead of having the organization do it and say, we have 4 more members that lobby for us. So instead of having one registration that would encompass all the lobbying that's done on behalf of that organization, we have possibly the organization and then 4 different consultants. And that's how it's dealt with in the provinces. We just have it's a problem with the act right now, and so it makes it very, I want to say dysfunctional, but it's fragmented, the type of information that you get about the organization. So it's just they are already required to register, but they register individually instead of being deemed employees of an organization.
Okay. Going back to Leader of the Opposition, his staff is considered designated public office holder under Section 128. Do we know, is that happening in practical?
So the staff in the office of the Leader of the Opposition are only designated public office holders if they are appointed under Section 128. I've been advised that none of them are. So they're not designated public office holders.
So the Leader of the Opposition staff is free to do whatever they want to do because they are not designated as a public office holder, because they are not appointed under 128 of the Act.
Currently, they're not designated public office holders, so people who meet with them would not have to do the reporting, and they also are not subject to the 5-year prohibition. But because the regulation right now says people appointed under 128 are designated, people assume that they are appointed under 128, so that needs to be clarified.
I think that's a big thing that we need to make sure that happens, because a minister and a Leader of the Opposition have the similar opportunities to do favors to friends if they wanted to.
Yeah, well,
When you appeared in October 2025, you said, like the provincial counterpart, you have no discretion power to make files public, or you don't have power for people to go undergo training and the ability to impose administration penalties. Can you explain why do you want the discretion to make public files is important? Why do you think you need the power for the people to undergo training?
I think the ultimate reason is to try to be more efficient in dealing with noncompliance and having the opportunity and the possibility to impose sanctions that are proportionate to the offense. So someone who's late and consistently late, I impose a penalty, chances are they'll never be late again. Now what I do is I tell them don't be late, they're late again, I send them a letter, and there's no consequences. And so, and right now, if I choose to investigate someone that's constantly late, if I have reason to believe that they're late and therefore they've done an offense, I need to send that to the RCMP. Not all offenses under the Lobbying Act are created equal, but unfortunately right now, they're all treated the same. And it's difficult to manage. I think it would help efficiency, and I also think it would help compliance because I would be able to make those things public faster.
Every province has those legislation?
I don't know. I would say every. Some provinces don't even have the power to investigate. But I've flagged in my report, British Columbia has powers to impose penalties. I think Alberta does as well. I think Ontario only has the power to prohibit. So it's a little bit, I've given you examples in my recommendations.
Right. Okay.
I don't know them all by heart.
Monsieur Hardy, 5 minutes.
Alors, on a un sujet très intéressant à parler.
This is a very interesting topic. The former defense minister under Justin Trudeau created a business, a startup, that seeks to receive a government contract, and we're talking about life after politics. Everybody wants that, but this leads to certain questions. His client would be Canada. He has a lot of contacts, a lot of networks. Is this something that should be considered under the Lobbying Act? One moment, Mr. Hardy. We have a point of order.
With great reluctance to interrupt, could we please refrain from using examples of real individuals in hypothetical circumstances? I just think that does a bit of a disservice to all parliamentarians.
C'est dans le journal.
It's Mr. Hardy's time. He's going to bring it back to whatever point he wants to make. I generally don't interrupt any member, whatever direction they want to go, because it's their time. So, Mr. Hardy, recommencez, s'il vous plaît.
Donc, on repart.
I'll start again. Do you believe that when we look at the lobbying legislation, because we're dealing with a private business, it is legal and it is not covered by the Lobbying Act? If I understood correctly, he can start a business, and I'm talking about him, but there could be other examples. So there wouldn't be any issue with him seeking to have the Government of Canada as his client. As a business owner, he can use his contacts for that. I just want to be careful there when we're talking about having the Government of Canada as a client. When public office holders, designated public office holders leave office, they can do whatever work that they want, but what concerns me is communication with the federal government regarding topics that are considered lobbying. And because former public office holders are prohibited from this, this is why I have to look into this. Now, if we're talking about a contract, that's not considered lobbying. That said, if it is a communication in order to receive a grant, that is lobbying, and the business, or rather that person who's a former office holder, would be prohibited from that. but his employee could do it. Yes. Understood. Is it possible for someone to phone someone in government to ask where things are going, because they're leaving their political career, they're thinking of starting a business, and they want to know what field to look into and what the trends are so that they have a startup in that field? Do you think that that's a problem, to potentially have a contract with the Government of Canada without going through your office? I believe that receiving a contract should be subject to the Lobbying Act, and I do have a recommendation to that end. Now, regarding former public office holders, if they can create a startup business in fields that they are very knowledgeable on and they have an expertise on, that would be under the purview of the Ethics Commissioner and Conflict of Interest Commissioner. But if somebody wants to start a lobbying business, if they have a lobbying business and they respect that 8 hours a month, and if they do, and they can't do over 8 hours, if it's a lobbying company, they will have clients. And as these lobbyists, consultant lobbyists, it's not allowed, it's prohibited. If they create a business with consultant lobbyists and the employees are doing this lobbying work, that is allowed because they are not the ones communicating. Lobbying is communication. If they're not doing any communication, well, then it's fine. Well, perhaps that's a bit of a loophole that would allow someone with all of these contacts, all of this knowledge, to share this with their employees. So perhaps we should look into that as well. If you're doing lobbying on behalf of, then we should act. Thank you. Thank you, Mr. Hardy. Mr. Sari, you have 5 minutes. Thank you again. It's great to hear from you. I find your expertise fascinating. I've been a part of this committee for a little while now, and we have talked about access to information, and that's quite important. And this leads me to ask you a question on Recommendation 12, which talks about the monthly communication reports for all lobbying of designated public office holders. In my first question, I talked about what led you to making these recommendations. Now, I have a question, and you have 35 employees, correct? If we want to apply one of these recommendations, I would perhaps have a question regarding the feasibility and the applicability of a recommendation, because access to information and disclosure, we want to know if somebody respected the legislation, but we also want to know if all of the proper documentation was sent in. Is this recommendation truly feasible? That reporting obligation is for organizations and corporations, not for my office. We can verify this information. And so with the 9,000 lobbyists, there will be others that will be added to the list eventually. We base ourselves on goodwill. Under the current regime, most people are compliant. We don't have a lot of investigations when you compare it to the number of current lobbyists. I was a former assistant commissioner to access to information, and so access and transparency are values that shouldn't be trifled with. I'm from Quebec, and I was one of the first to say that information needs to be public. I just wanted to ask a question on the feasibility of verifying all of this with 35 employees. Or perhaps would you need more resources? Perhaps eventually we might need more resources. With 35 employees, my current issue is that in a few years, I won't have enough funds to pay for licenses and things like that, so I won't be able to have more than 35 employees. But that doesn't mean that we can't verify information. That's done quite easily. I ask you, did you meet with the person? You say yes or no. Yes, but making that information public. I'm not the one who makes it public. It's the lobbyists themselves. But we need to. Do you need to verify whether or not they made it public? Well, once it's made public, we'll verify. We'll verify if they did not do it. That's what my question is on. It's the matter of feasibility regarding whether or not they registered correctly. I would like to come back to the matter of the official opposition. And you stated that most lobbyists believe that the staff of the official opposition's office are public office holders. That doesn't mean that all lobbyists believe that. Some of those lobbyists were not registered and have ties with the Office of the Official Opposition. Would that be possible? If somebody communicates with the Office of the Official Opposition, they are public office holders, and so they need to be registered. They need to register and say that they intend to do lobbying at the House of Commons, the Senate, or some departments. What's missing is the communication report. If they organize a meeting with someone from that office, they don't have to send in that report. They have the obligation to be registered, but not to have the monthly report. And the opposition leader, can he appoint team members as designated public office holders? He can, if he wants. That's part of the legislation, yes. But currently, none have been appointed in that way. That's the confirmation that I've received. That is what you have been given as information. And so, I can say that nobody was appointed in that way according to information given. That's the information I was given indeed. Thank you, Mr. Sari.
Meeting. I want to thank you for spending this much time with the committee. I've found the discussion very enlightening today, and I know that you're going to be watching this study as we go forward, and I do expect that an invitation will be given to you at the end of the study to come back and draw some conclusions on what you've heard and what you've seen at this committee. Again, thank you on behalf of the committee, and thank you on behalf of Canadians for being here at the start of this very, very important and timely study, and I know you've been pushing for it, so I'm glad we're able to do that. In saying that, however, I want members of the committee to be prepared on Thursday to come to deal with the report that we're working on the Conflict of Interest Act. Okay, so that's what we're going to be doing on Thursday, and I suspect we'll be continuing that on the Monday following next week's break week. So I have no other business today. Thank you, everyone. Thank you, Commissioner. Meeting is adjourned.